Hello, everybody. All of my beautiful, lovely people, positive people, all of my beautiful natural beings. Yo, I love all of you. And I just want you to know that you are part of this great movement that is spreading love, compassion, and natural rights, knowledge, and wisdom to the people. And we're doing it for the people. It's not about being belligerent. It's not about being anti government. We not. That's not the point. Y'all know it's not. We're not trying to attack anybody. We just want our rights upheld, respected, and brought to the forefront so that we can flourish as a community again. So with that being said, yo, y'all welcome. What is this? Part four? Is this five? Oh my gosh, I'm losing track. I don't know. Yo, man, this is awesome. So let's get straight into it. Let me throw this bad boy full screen real quick. So we stopped off right about here, if I'm not mistaken. So we're gonna keep it going. So the state cannot demand, and I hope everybody's been following along pretty good. I see that y'all have been asking a lot of questions in the comments. I'm trying to answer every single one, literally. So ask away, please. The state cannot demand from the sovereign people what it never had a right to. Then there is the issue, of course, of public policy. Now, public policy, aka the statute, is just that. It's a public policy and does not transcend the private. However, if this argument is used, it too must fail, as, quote, no public policy of a state can be allowed to override the positive guarantees of the U.S. Constitution. Guarantees, again, it's not given, but they're guaranteed to be protected, unquote. So this is a 16 Am Jurors second edition, or second Constitutional Law, Section 70. Quote, again, statutes that violate the plain and obvious principles of common right and common reason are null and void, unquote. Bennett versus Boggs. So, even public policy cannot abrogate the citizen's right to travel and use the common highways in the ordinary course of life and business. Therefore, it must be concluded that, quote, we have repeatedly held that the legislative may regulate the use of the highways for carrying on business for private gain, and that such regulation is a valid exercise of the police power, unquote. Quote, the act in question is a valid regulation, and as such is binding upon all those who use the highway for the purpose of private gain, unquote. Northern Pacific Railroad Company versus Schoenfeld. Now, it is possible to go on quoting court decision after court decision, but it is not necessary because the Constitution itself tells us a government cannot legally put restrictions on the rights of the American people at any time, nor for any reason. So that right there should put you on point. It's like, yeah, we going through all of this case law and we're like showing it all, but still they're not trying to up. It's like, bro, like you need to really just get to the point to being like, yo, it's null and void. Like, why are we sitting here having this argument? You really just, it comes down to logic, but then again, it comes down to control. And again, if the statutory courts are continuing to act the way that they act, you're just going to have to push that bad boy up. Let's just take it on up. I don't want to talk to you no more. You really ain't got no common sense. Your logic isn't there. You ain't nothing really. I'm sitting here calling you judge, but you're really just the highest clerk within the statutory corporation that you work within. You have no jurisdiction or control over me. You just work for this corporation known as the city of Blase Blase. I mean, literally, that's what it boils down to. Quote, this Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be made in pursuance thereof, shall be the supreme law of the land, not your little statutory revised codes or your statutes. It don't work like that. We hip to it now. The average person is learning law. Guess what, buddy? We learning the law. And the judges in every state shall be bound thereby. Bound, you are bound to uphold my guarantees. And if you violate those guarantees, any of you agents, any of you highest clerks, it's like we ain't just going after the police officers anymore. We going after the clerks as well. I mean judges. Shall be bound thereby, and anything in the Constitution or laws of any state to the contrary not one word withstanding, unquote. In the same article, it says just who within our government are bound by this supreme law. Quote, the senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Unquote. The state cannot proceed upon presumption. The state cannot proceed upon presumption. The presumption that someone allegedly violated some business regulation is based on a presumption that someone was driving as defined by statute. The presumption that someone allegedly violated some business regulation, speeding, no insurance, no valid operator's license, is based on a presumption that someone was driving, one employed operating a motor vehicle, as defined by statute. The law against presumption is found in 5 ALR 3D 100, inference on inference et sec. The rule, quote, the rule that it is not permissible in making a case or proving an issue to draw one presumption based on another presumption may be found stated in many cases. United States versus Ross, Manning versus John Hancock, Looney versus Metropolitan. So, the presumption that officials have done their duty is limited by the rule that a presumption cannot be based upon a mere presumption and will not supply proof of independent, substantive facts, such as that a deficiency judgment was entered and docketed by the clerk of the court. Mahoney versus Boise Title. Now, that one's really big, bro. Oh, man. I think what we got to understand is how the law works. And let's read this again, okay? The presumption that officials have done their duty is limited by the rule that a presumption cannot be based upon a mere presumption and will not supply proof of independent, substantial facts, such as that a deficiency judgment was entered and docketed by the clerk of the court. Just because they say it so don't mean it. Just because they say it so don't mean it's so. You got to have the substantive facts. The substantive facts don't show a contract to impose your business regulation. If there ain't no contract, or if you're not found in the action or duty of transporting goods, right, passengers, using the roads for actual profit. And I've had this question come up a lot, so I just want to clear it up real quick. It's the aspect of saying, hey, well, if I'm traveling to a place to make money, let's say like I'm an HVAC driver. I think I've already actually mentioned this. Like if I work for a business like HVAC company, me going from point A to point B to get to my work site, you don't have to have a driver's license for that. You see what I'm saying? You're not utilizing the roads to make money. You're making money at your destination, not making money while on the roads. Okay? So we're just clearing that up. So, where circumstantial, and this is a quote, so quote, where circumstantial evidence is proper, since the same consists in reasoning from facts which are known or proved to establish such as are conjectured to exist, the process is defective if the circumstances from which it is sought to deduce the conclusion depend also upon the conjecture and speculation. Unquote. St. Louis versus Mobley. You know when they say, objection! Speculation! Hey, that speculation ain't gonna hold in court. Y'all better start objecting. So, the federal preemption. Title 46, 47, and 81 of the Revised Codes of Washington are intended to complement the Federal Motor Vehicle Act at 49 U.S.C., 23 U.S.C., and 23 CFR, and 49 CFR. The state codes apply to intrastate commerce, whereas the federal counterpart applies to interstate commerce. The state would have absolutely no control over interstate commerce, common carriers, if they, said state, were not certified to participate in the Federal Motor Carrier Act. Quote, this declaration of intent demonstrates that the act was intended to cooperate with the federal act and to be construed in connection therewith. Section 21 of Initiative 141 Supra expressly provides that if any portion, section, or clause of the act shall be declared not in accordance with the provisions of the Federal Social Security Act, such adjudication shall not affect the remainder of the act. By this provision, the intent that the act shall accord with the federal statute is made doubly clear. Further, the federal is not subject to criticism as to its reasonableness or legality. It is manifestly the intention of the state act to place the state in a position to avail itself to the full of the benefits of the federal act, and the state statute negatives the idea that it was the intention of the act that the state proceed upon its relief program independently of the predominant partner, the federal government, in administrating relief funds, or upon any plan or system different from that established by the federal act. The federal and state statutes represent a cooperative legislative effort by state and national governments for carrying out a public purpose common to both, which neither could fully achieve without the cooperation of the other. Unquote. Carmichael versus Southern Coal and Coke, Northwestern Mutual Life Insurance Company versus Tone. And this is also within the James R. Morgan versus Department of Social Security. Now, what I also found very fascinating, I know you're probably thinking about more or less the quote there and the implications, but this right here, it said the federal and state statutes represent a cooperative legislative effort by state and national governments. Okay, never mind then. I was thinking something else there for a second. Okay. So, in keeping with the spirit, y'all, of the above citation, we find similar language in the statutes of the state of Washington, keeping in mind the rule expressio unius est exclusio arteriis, to specifically identify a person, class of persons, or intent, impliedly excludes all others. The following statute specifically declares complement to federal statutes. RCW 46.25.005. Purpose, construction. The purpose of this chapter is to implement the Federal Commercial Motor Vehicles Safety Act of 1986. There it is. And reduce or prevent commercial motor vehicle accidents, fatalities, and injuries by permitting commercial drivers to hold only one license. B. Disqualifying commercial drivers who have committed certain serious traffic violations or other specified offenses. C. Strengthening licensing and testing standards. 2. This chapter is a remedial law and shall be liberally construed to promote the public health, safety, and welfare. To the extent that this chapter conflicts with general driver licensing provisions, this chapter prevails. Where this chapter is silent, the general driver licensing provisions apply. As shown above and amplified below, again, it is declared by the legislature that state statute is to be implicitly factored in relation to federal law. Below, we see the use of the term other laws, which includes federal laws and other state laws, through the Interstate Driver Compact at RCW 46.21.010. The vicious use of the phrase other laws, or all laws, is an inclusive mandate to read statutes in pari materia. This declaration is demonstrated as follows. RCW 46.98.020. Provisions to be construed in pari materia. The provisions of this title shall be construed in pari materia, even though, as a matter of prior legislative history, they were not originally enacted in the same statute. The provisions of this title shall also be construed in pari materia with the provisions of Title 47 RCW and with other laws relating to highways, roads, streets, bridges, ferries, and vehicles. This section shall not operate retroactively. Another one. The starting point for every case involving statutory construction is the language of the statute itself. Landreth Timber Company versus Landreth. 471 U.S. 681, 1985, and Miller versus Department of Transportation. Where the statutory language is clear, it must control absent clearly expressed legislative intent to the contrary. Statutory provisions should not be read in isolation. Rather, each section of a statute should be construed in connection with other sections as to produce a harmonious whole. Style Slinger versus Department of the Army. Further, under the general rules of statutory construction, Congress can be presumed to have known that its selection of the broader phrase by law in the absence of any limiting language could expand the scope of the exemption to include all law. You hear that? Uh-oh. So now we're starting to see a little bit of the trickery. And this is D'Elia versus Department of Treasury. And this one, Thomas overruled in part on other grounds by Gansky versus Department of the Interior, 1998 and 2000. That was also another one by McLean versus the Department of Homeland Security in 2009. That might be a good case to look up. You can see the docket number right here, y'all. You can look that one probably up on courtlistener.org. Okay, so under the Supremacy Clause of the United States Constitution, the laws of the United States shall be the supreme law of the land, anything in the Constitution or laws of any state to the contrary notwithstanding. U.S. Constitution Article 6, a state law which conflicts with federal law is unenforceable. A state law which conflicts with federal law is unenforceable. A state law that which conflicts with federal law is unenforceable. Y'all like my slowdown I did right there? It's like my own slow-mo. No, I didn't put it on slow-mo. I'll try it again some other time. All right, because the purpose of Congress is the ultimate touchstone in every preemption case, analysis of the federal statute must begin with its text, including the structure and purpose of the statute as a whole, unquote. Medtronic, Inc. versus Lohr, and Retail Clerks versus Schermerhorn, and Gade versus National Solid Waste Management Association. Hold on one second, need a drink. I'm reading a lot. You always gotta like a good when it comes to some sweet tea. You know, I'm a Texan, so we like sweet tea, okay? Yeah. If any of y'all ever want to send me some good sweet tea packets, if you got great tea and you just want to share some, let me know. I'd love to get sent some tea. If you do want to send me any tea. Okay, so as discussed above, unenforceable. We went through this. Federal law is enforceable. Yep. No, we didn't read that. Didn't I just read that? I don't know. Whatever. So Title 23, Highways, Chapter 3, General Provisions, Section 308, Cooperation with Federal and State Agencies and Foreign Countries. A. The Secretary is authorized to perform by contract or otherwise authorized engineering or other services in connection with the survey, construction, maintenance, or improvement of highways for other government agencies, cooperating foreign countries, and state cooperating agencies, and reimbursement for such services, which may include depreciation on engineering and road building equipment used, shall be credited to the appropriation concerned. Okay, and that's under the Title 23 Highways, Chapter 1, Federal Aid Highways, Section 154, Open Container Requirements. B. Open Container Laws. 2. Motor vehicles designed to transport many passengers. For the purposes of this section, if a state has, in effect, a law that makes unlawful the possession of any open alcoholic beverage container by the driver, but not by passengers, A. In the passenger area of a motor vehicle designed, maintained, or used primarily for the transportation of persons for compensation. Right, okay, so we're just going over some details here, I'm assuming, through this documentation. Great, okay. So RCW 46.61.519, alcoholic beverages, drinking or open container in a vehicle on a highway, exemptions. 3. It is a traffic infraction for the registered owner of a motor vehicle or the driver, if the registered owner is not then present in the vehicle, to keep in a motor vehicle when the vehicle is upon the highway a bottle, can, or other receptacle containing an alcoholic beverage which has been opened, or a seal broken, or the contents partially removed, unless the container is kept in the trunk of the vehicle or in some other area of the vehicle not normally occupied by the driver or passengers if the vehicle does not have a trunk. A utility compartment or glove compartment is deemed to be within the area occupied by the driver and passengers. 4. This section does not apply to a public conveyance that has been commercially chartered for group use or to the living quarters of a motorhome or camper, or except as otherwise provided by RCW 66.44.25 or local law to any passenger for compensation in a for-hire vehicle licensed under city, county, or state, or to a privately owned vehicle operated by a person possessing a valid operator's license endorsed for the appropriate classification under Chapter 46.25 RCW in the course of his usual employment, transporting passengers at the employer's direction. Man, did you hear the language in that one? Clearly distinguished it, didn't it? Because it says for compensation in a for-hire vehicle. If you ain't seen on my community, I guess, you can put like posts on the community, whether it's like text or pictures or stuff on YouTube. If you click on the community tab, videos, playlists, all that stuff at the top, you can see I just put up some pictures of the old plates, how they were just having them, not for hire. They would just have not for hire plates put on, y'all. They didn't have to pay nothing. They're not for hire. Like, that was their way of identifying. Hey, throw it on. You're good to go forever. As long as you keep the car, that's yours. The car, it stays with the car. You're not for hire. You start using this car for hire, you gotta get you some plates. You gotta pay some tax. Hello. I'm pretty sure I know what happened. Let's logically think about this for a second. Let's take a trip down hypothetical memory lane. Let's try and tap into what they call the Akashic record. Okay? And let's just think logically for a moment. Do you not think that there were people getting by using those plates, not for hire, and they were actually on the roads making money? So apparently at some point, and we will get there, I promise you, y'all, I have newspaper clippings right now talking about this subject that we will go over. Not in this series, but we're going to go over them soon. I've been doing my research. Okay? They were talking about what's going on in the newspapers. We can get newspapers, the old ones. We got them. Let's continue. We'll talk about that later. Okay. Anyways. But all the language is here. And y'all have been learning the language with me. So we now know compensation for hire. Again, a valid operator's license endorsed for the appropriate classification in the course of his usual employment, transporting passengers, provided that nothing in this subsection shall be construed to authorize possession or consumption of an alcoholic beverage by the operator of any vehicle upon the highway. In the above statute, albeit long-winded, diluted yet still opaque, the state of Washington has committed itself to the rule of preemption by showing conformity to the federal mandate. This simple agreement is in and of itself sufficient to show that the expression of drinking and driving is specifically and only designated to for-hire vehicle drivers and operators, notwithstanding the Federal Motor Carrier Safety Act. Now, you already know how I feel about drinking and driving. But I also don't like the aspect that people can get in trouble either before they've even committed any harm. So I'm just going to say that too. I'm on the fence. I guess y'all just need to tell me how you feel about it in the comments, and then we can have a discussion a little bit more. Let's do it like that. So on the rule of preemption, Epstein's case note, Legal Briefs Torts, defines the preemption rule of law as concise rule of law. Federal law implicitly preempts an area traditionally regulated pursuant to the state's police powers if the state and federal law are in actual conflicts or the state law frustrates Congress' intent, unquote. Epstein relies on this holding of the following case. The Supremacy Clause of the Federal, quote, the Supremacy Clause of the Federal Constitution provides that any state law in conflict with a federal law is preempted by the federal law and has no effect. Preemption only applies where it is clear that Congress intended preemption to apply. Preemption is accomplished in several ways, expressly by pervasive regulation in a particular field, or by implication where state and federal law conflict so that it is impossible to comply with both. Lewis versus Brunswick Corporation. So what are we learning here? Okay, that preemption is a major deal. We need to now start talking. I've have not used preemption. I've not used this aspect within any of my motions or the abatement. So this might be a good clause or aspect that we can introduce into an abate. Might look into also formulating a preemption documentation to submit to the courts for any of the sightings in which anybody's getting and you want to get it wiped, right? Because I think even if you have a driver's license, let's say you currently have a driver's license right now, and you're like, Cameron, I got a driver's license and I was speeding, right? Or I didn't have insurance. You can still go to court pro se by learning, like we are doing, the law, and implementing some of the things like we do in the right to travel course, and utilize the information and formulate something that you can submit to the courts and see if the courts are going to honor and respect that. Because now we're getting into the deeper stuff. We're getting away from statute so much, and we're now getting into those technicalities of playing chess. Remember, I told you this is a chess game. Cases can be thrown away based just on technicalities, right? Jurisdiction is a technicality. Corpus delicti is a technicality. Verified complainant is a technicality. All of these are technicalities. It's not the underlying foundational aspect of what brought you there in the first place, the charge, the violation. But the technicalities can have it all wiped away. And preemption is a new technicality in which we can apply. So pay attention, because I'm learning too. It is irrepressibly shown throughout this writing, and more predominantly in the first two chapters, that the U.S. Supreme Court has reverently, and concisely stated that the people have the right to freedom of movement and the right to the free use and enjoyment of their personal property, and of the uninhibited use of the highways. Uninhibited use. Uninhibited use, meaning do not stop. Do not. And the problem is they don't know. So, do they get qualified immunity because they don't know? Because we don't get qualified immunity when we don't know. You see what I'm saying? Do they give us a break? Where's my qualified immunity? If I'm the highest and I pay all of y'all, where's my qualified immunity? Oh, that's right. It's in the knowledge in which I gain by reading the law. Gotcha. We're coming. Don't worry. The Supreme Court has final authority to determine meaning and application of those words of the Constitution, which require interpretation to resolve judicial issues. Pennekamp versus State of Florida. I guess that is State of Florida. No, that's FLA. What? I don't know what that's supposed to be. What? I'm lost. The construction given by the United States Supreme Court to the Constitution and laws of the United States is to be accepted by all courts as the proper construction. The construction given by the United States, the construction, opinion, case law, opinion given by the United States Supreme Court to the Constitution and laws of the United States is to be accepted by all courts. Is to be accepted by all courts. And why is that? Because that Chevron deference has been repealed, baby. As to the proper construction, this is Elmendorf versus Taylor, 23 U.S. 152-10, Wheat, 152-6 LED, 289 in 1825. Decisions of the United States Supreme Court in cases involving federal questions are conclusive authorities in state courts. Provident Institution versus State of Mass, 73 U.S. 611 6 Wall, 611 18 LED, 907 1867. Do I keep going? Yes, we're only 20 minutes in. 28 minutes in. Municipal regulation. Okay, so what I want to do before jumping into the municipal aspect is I want to bring your attention to this document right here. This document is called The Laws You Didn't Know Exist. If you don't have this, I think I'm on page, like, what is this, page 28 or something like that. I'm on page 28, and I've literally been, all the pages are is almost quotes like this from case law. You can get this document when you go to the website for the Right to Travel course. All you got to do is sign up, and then it takes you right there. It's not going to email you. As soon as you sign up, it's going to open up a page with the course and everything you need to do. So save that link, because that's your link to get back there, okay? But what I want to bring your attention to real quick is this right here. Okay, this section of understanding what's going on with your municipal courts, okay, and the judges that work there. And I want you to understand this is the quotes. These are opinions, okay? Number one in this 5 right here. Actually, let me see if I can make it a little bit bigger for y'all. I'm probably sure y'all can't see it as well as I can. Oh, let me see. Zoom in. 150. Hopefully that's not too big. Okay, so I'm not doing any bigger than that. All right. We're right here on 5. Judges who become involved in enforcement of mere statutes, whether civil or criminal in nature and otherwise, act as mere clerks of the involved agency. K.C. Davis, Admin Law, Chapter 1, CTP, West 1965 edition. Did you hear that? Do I need to read it again so you start to understand what you are missing? Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency or corporation or business. Look up the municipal city that you have to go to court for your tickets and find the DUNS number. Go to Duns and Bradstreet and find their DUNS number because they're a corporation. Let's read number 6. Their supposed court, quote, their supposed court becoming thus a court of limited jurisdiction. Hello? Those in contract. That's what limited jurisdiction means. As a mere extension of the involved agency for mere superior reviewing purposes. Oh my God. Mere superior reviewing purposes, unquote. K.C. Davis, Admin Law, page 95. Okay? And this is also FRC versus GE 281, US 464, also Keller versus PE 261, US 428, quote. When acting, number 7, quote, when acting to enforce a statute, the judge of the municipal court, remember we're getting into municipal now, okay, is acting as an administrative officer and not as a judicial capacity. Did you hear that? So I'm gonna finish this one and then we'll go into it. Courts in administrative or enforcing statutes do not act judicially, but merely administratively, unquote. Thompson versus Smith. My people. We're going to do a dummy breakdown on this one, okay? We got to do a dummy breakdown. Now, I'm sorry that I'm going to break a lot of people's hearts here that really want to believe that these clerks have power and dominance over me, the I am, the living creation and being, but not today, buddy. So, here we go. We're breaking it down in dummy form. Okay, there's the original statement when acting to enforce a statute, right? We already know. Simplified explanation. I'm going to go about this fast. Get ready. 1. Enforcing a law. What it means. Making sure that a specific law is followed, of course. We're not going to go through this dummy stuff. Role of a municipal court judge. Administrative officer. Think of this like a manager who makes sure rules are followed. Not a judge in a courtroom. They aren't making big legal decisions like in a higher court where important cases are decided. Administrative versus judicial. Administrative actions. These are everyday rule-checking tasks like issuing parking tickets and fines. Judicial actions. These involve deciding who is right or wrong in bigger legal cases like in a trial. What the judge, the clerk, is doing. Administrative role. When the judge is enforcing the law, they're acting like a manager, making sure that the rules are followed. Okay? That's it. Okay? They're like a state principal, bro. You know, making sure that everybody that's registered for school. Bro, I'm not registered in your school, bro. You know what I'm saying? Like, no, you know. But like it says in Thompson versus Smith, yo, man, these guys are not judicially. They can't really affect you if you apply yourself and know. 8. It is basic in our law that an administrative agency may act only within the area of jurisdiction marked out for it by law, meaning both territorially and contractually. If an individual does not come within the coverage of the particular agency's enabling legislation, the agency is without power to take any action that affects him. Any action that affects him. Edicott versus Perkins. Now, what's crazy is that we have people in the comments, you're seeing them. Oh, this sovereign citizen BS, this constitutionalist BS. Bro, these are the people that, this is the Supreme Court. So you're apparently treasonous. You're committing treason. It's kind of like those guys that was with Luis's situation, if you've seen it, where they're literally coming up to him and like, oh, we're not going for this constitutionalist BS. It's like, bro, I'm not even going to. I've covered this before. Number 9, quote, it is not every act legislative in form that is law. Law is something more than mere will exerted as an act of a power, arbitrary power. Enforcing its edicts to the injury of the person and property of its subjects is not law, unquote. Did you hear that? So when they talk about the harm that's being brought against us, when I speak on that, it's already been spoken of. It's not like I'm just coming out here and being the only one. It's already spoken of. Arbitrary power, enforcing its edicts to the injury of the person and the property of its subjects is not law. You're injuring us. That's not law. That's the point of what they're trying to say. The Supreme Court ruling in Hurtado versus California understood that, hey man, if y'all are out here just harming people because of these laws, like if the laws that you're making are harming people and their property, that's not really law. It's not supposed to be just like out here harming them. Okay. 11, quote, every consent involves a submission. Oof. But it by no means follows that a mere submission involves consent, unquote. Regina versus Day. And that one's a big one. So this document here, again, like I said, is in the Right to Travel course within all of the documents that I provide. This one's called The Laws You Didn't Know Exist. And dude, it is, I'm talking about pages on pages on pages on pages on pages. We got 108 pages of nothing but quotes. Of nothing but quotes. So you could literally, whatever situation that you are realistically in, you could come in here and push, you could come into this document, Control F, Command F, search your term, and see if you can find what you need to find that pertains to your case. It's what I do. It's what I do for my people, my clients. But sometimes, we just got to put on our big boy shoes and get to it and do it ourselves, Okay, so let's get back to municipal regulation. I just wanted to bring out that clerk aspect because I really think that y'all are going to see now that you understand that it's not just Supreme Court. There's lots of laws, There's contract, trust, administrative law, like all of it. You have to really bring it all. UCC. UCC is going to be a big one. And we'll get in that. But all of it paints the picture. It's like if you're just looking at one section, you're never going to if you only have a, 1/4 of the puzzle, you're never, you can't see the whole thing. The courts are duty bound to recognize and stop the stealthy encroachments which have been made upon the citizen's right to travel and to his personal private use of the roads. Hadfield Supra. Further, the court must recognize that the right to travel is part of the liberty of which a citizen cannot be deprived without specific cause and without the due process of law guaranteed in the Fifth Amendment. Kent Supra. Quote, in general, municipal corporations possess no power to encroach on individual rights unless such authority is plainly conferred by the city charter or other law, and municipal ordinances ordinarily should not contravene those principles of common right. Those principles should not contravene those principles of common right, which are embodied in the common law. Common law has not been repealed. It's not like it don't exist anymore. It's not like you just say, oh, administrative law is the only law. No, it's the only law in which they want to go by because that's the only law in which they can go by. They're bound by it. They're a company. They can't go into common law. They're an administrative agency. I'm telling you, I don't know what y'all don't get now about this. You can understand it. Ferran versus City of Palo Alto, 1942, and McKelly versus City of Murfreesboro. It is the duty of the court to recognize the substance of things and not the mere form. This is a big one. Quote, the courts are not bound by mere form, nor are they to be misled by mere pretenses. They are at liberty. Indeed, they are under a solemn duty. All of our public servants are of under a solemn duty. And I'm going to stop this quote for a second. That solemn duty used to be something that people were proud to be a part of. People used to be really, really proud to serve, to be a benefit of the greater good, to be a benefit to their brethren, to be a benefit to their community, to live up to standards that show that they can be a light, a beacon for the Creator. Thanking the Creator, being thankful for life, being grateful for all that we have. It used to be something that you could take pride in. It was a solemn duty to protect the rights that we had finally earned ourselves after so many years of toil and pain, and that so many of our family members and ancestors died for. It was a solemn duty, and we were proud. We were proud to be the best that we could be. And now we have a whole bunch of people that are pansies because they're given everything and they don't know that it can all be taken away, and they're comfortable. It saddens my heart, man. It really does. So indeed, they are under a solemn duty to look at the substance of things whenever they enter upon the inquiry whether the legislature has transcended the limits of its authority. If, therefore, a statute purported to have been enacted to protect the public safety has no real or substantial relation to those objects, or is a palpable invasion of rights secured by the fundamental law, it is the duty of the courts to so adjudge, and thereby give effect to the Constitution. Another quote that should be brought up so easily in court for any instances that you may have. Unquote. So this is Mugler versus Kansas. 123 U.S. 623661. A municipality has no authority, subsequently no jurisdiction, to prosecute claims of a commercial nature against private citizens not commercially engaged, more because the highways passing through a city are extensions of highways preemptively regulated by state and federal laws. When the state chooses to regulate and act under its police power, this is a quote, its laws and operations predominate over the local laws and ordinances. Municipalities may not adopt ordinances that are inconsistent with state law. A state statute which preempts a field precludes local agency or government legislation on the subject, unquote. 56 Am. Juris Second, or 2D, Municipal Corporation, Section 391. See also Olinger versus Bennett in 562 NW 2D 167, and as well as Thomas versus State 614 SO 2D 468. A city may not attempt to regulate beyond its jurisdiction. City of East Lansing versus Yoka 142 Michigan App 491 369 NW 2D 918. The focal point of this question of police power and due process must balance upon the point of making the public highways a safe place for the public to travel. The focal point of this question of police power, police, listen up, this is really all you need to know. And due process must balance upon the point of making the public highways a safe place for public to travel, and only those commercial and those, speeding causing, harm, possibly. A local municipality may induce reasonable regulations. For instance, when a person could block a portion of a road for a parade, or erect barriers to protect the public from a sinkhole, or designate certain portions of the road for public parking. Quote, a municipality may impose other regulations adapted to its own peculiar conditions if they are not inconsistent with those of the general character prescribed by the state. Unquote. Am. Juris 2D, Automobiles, Section 20. Quote, municipalities retain considerable authority to regulate how motor vehicles engaged in interstate commerce shall be operated over the streets, and may require that such vehicles obey traffic and other general safety regulations. Unquote. Am. Juris 2D, Automobiles, Section 29, citing City of Chicago versus Atchison. T. and SF, Rye Co. 357 U.S. 7778 SCT 1063. On the other hand, a municipal regulation is not necessarily rendered invalid by the mere fact that private rights are subjected to restraint or that loss will result to individuals from its enforcement. This is more to parking enforcement, for instance. Dennis versus Village of Tonka Bay. Man, there's a whole bunch of cases here. I'm not reading all those. Quote, as long as municipal bodies confine their enactments within the proper limits of their police power, they do not unlawfully violate the private rights of the individual. Read again, read again. As long as a municipal body, you cities out there, and all of you police, law enforcements, especially the city ones, y'all are at the very lowest totem pole as far as line of authority is concerned. So just remember this. As long as the municipal bodies confine their enactments, okay, so within the proper limits of their police power, they do not unlawfully violate the private rights of the individual. You start messing with our private rights, we're bringing it, bro. We're learning now. We got too much case law. We're not putting up with it no more. Nobody is going to allow you to do it anymore. I'm telling you, at least anybody that's watching my channel. These next few pages tell of municipal regulation and municipal authority from a myriad legal resource, which need no further narration on the part of this writer, as they are substantially clear on municipal abatement. As much as these judicial decisions and legal resources further explicate the breadth of this writing, the length of the citations remain to show judicial and legal consistency. However, the municipal police power must be so exercised as to not infringe arbitrarily or unreasonably on private rights. And that was a quote by within Murrow versus City of Wheaton, as well as Downey versus Sioux City, City of New Orleans versus Southern Auto Wreckers, Farrell versus City of Syracuse. You get it. It goes on and on. Another one, quote, whether they are personal rights or property rights. So it don't matter if it's personal rights or property rights. It don't matter either or. Okay, so Jello Company, Jello. Look at it. We're getting some good quotes coming out of Jello now. Hello, talking about those personal and property rights. Jello, thank you, Jello. Versus Brown. Miami Shores Village versus WN Brockway, and some more. So let's see if this one's a quote too. It is. Quote, the standard for evaluating ordinances claimed to be violative of due process or equal protection is whether a rational basis exists for the police power exercised or classification established by the ordinance, unquote. Autotronic Systems, Inc. versus City of Coeur d'Alene. Quote, local police power enactments must not interfere with private rights beyond necessities of the situation. And this is, unquote, so Hossman versus Dayton and quite a few more. Quote, any interference with the protected rights of the citizens of the municipality must bear a reasonable relationship to the public need served, unquote. Verified complainant, where is one, right? Can't go just out here like with my situation, with my City of Ridgefield situation. There was nobody of the public that called to complain about me parked on the side of the road. There was also nobody that called to say I was doing anything bad, to where they needed to call one of my clients, or I guess like a place of employment for me. If you want to classify it as that, which is not, but place of employment for me. Call up the place of employment as though you're speaking on one of the members of the public. Like, if it don't work like that, man. You can't mess with the protected rights, y'all. It's insane. But what I think y'all really need to understand by this is multitudes of things now that we're getting into as far as what we're learning, right? It's not just the right to travel. You do understand that. Are you getting a grasp of just now how it works overall? Overall. We ain't talking about just the right to travel. We're talking about overall. Okay? Any interference, and that's Metropolitan-Dade County Fair Housing and Employment Appeals versus Sunrise Village Mobile Home Park. Okay? Quote, the police power does not justify any interference with the citizen's constitutional rights that is entirely out of proportion to any benefit redounding to the public. Jeez, killer right there, and that's a 1995 one. City of Baton Rouge versus Williams. Quote, municipalities must not exercise their extensive regulatory powers in an arbitrary or discriminatory manner. Oh, they do. They're discriminating by out here giving you and I tickets when they know that they're not supposed to. When they pull us over and they don't see any commerce or goods, do they know that they're not supposed to give us one, but do anyways? What is that? That's treason. We're just not showing it to be. We have to start bringing it back. We have to start saying, Supreme Court, the Supreme Court's not going to say nothing if ain't nobody bringing it to their attention. Hello? It's like my boy Brandon Joe Williams bringing up the aspect of what is money? What is currency? Where did the currency that I borrow come from? Because it didn't come out their bank account. Looks like they made it up in a system of accounting right out of nowhere. I'm telling, hey man, it's deep out here. We're not going to go into banking right now. We'll do that at a later point. Municipalities must not exercise their extensive regulatory powers in an arbitrary or discriminatory manner. That's Nisi versus City of Johnson City. It is not within, quote, it is not within the police power of a municipal corporation to make a particular use of the property which, in the absence of legislation, is lawful, but which is of such a character that it may be regulated or controlled by public authority, conditional upon the assent or permission of private persons. When an ordinance thus attempts to confer power on some property holders virtually to control and dispose of the property rights of others, and creates no standard by which the power thus given is to be exercised, so that the property holders who desire to have the authority to establish the regulations may do so solely for their own interests, or even capriciously, I hate these words sometimes, constitutional limits have been violated. 56 Amjurs, 2D, municipal corporations, etc. Section 400, cites omitted. Quote, a municipal ordinance which commits the exertion of the police power to the option of individuals to determine whether the use of property for a purely lawful purpose offends the health, safety, or welfare, and violates the fundamental principles of the police power. Appeal of Perrin. Quote, as a general rule, the owner of private property is entitled to the enjoyment thereof, free from municipal interference. However, a municipal corporation in the exercise of its police power may make regulations with respect to property within its borders, provided the regulations are reasonable and bear a substantial relation to the preservation of the public health, safety, morals, and welfare. Also below is the same one that is included, same case law here, Teglund versus Dodge, which is, quote, in general, and except insofar as concerns the exercise by the municipality of its police powers, the owner of private property, located within the municipal boundaries, may use it for any lawful purpose, or in any lawful manner that he may see fit. Again, that's also in Teglund versus Dodge, as well as Tillotson versus City Council of City of Cranston. Quote, a municipal corporation may not interfere with such right. Unquote. Benier versus Tribet. Town of Clinton versus Ross. But unless, quote, but unless or until harm or damage, oh no, here we go. Clarification, right in that case law that we was looking for, right? Weren't you looking for this one? Didn't you want to hear it? Because I could have swore Luis said it a lot, and they still don't want to listen. But of course, it's because they lack the knowledge. But unless or until harm or damage, a crime. Look at there. What is that? Do you see that parentheses? Does it say anywhere on here that they added anything? Nope, nothing added. So this was part of the quote. But unless or until harm or damage, which is thereby a crime, and only a crime, is committed, there is no cause for interference in the private affairs or actions of a citizen. 56 Amjurs 2D Municipal Corporations, etc. Section 396. I'll do one more quote before we close this one out. Municipal police regulations must also operate in a manner that is not arbitrary, oppressive, or fraudulent. Unquote. City of Russellville versus Vulcan Materials, as well as Wilson. Hey, Wilson versus City of Cincinnati. Wright versus Woodridge Lake Sewer District. 1991, 1980, 1976. These ain't old boys. These are recent. Well, I mean, not within the past 20 years, but within generation. So, if it's arbitrary, if it's oppressive, which I can find it very oppressive if you're trying to regulate. See, it's repugnant to try to administer a free man. It's repugnant to his freedom. Do you understand what I'm saying? It's like nasty. Like it's so gross that you would try to administer a free man. You can't do it. It's repugnant to his freedom. So, if you try to eliminate my happiness, you're oppressive. Not only that, you're fraudulent. Because you're out here telling me right now that I'm a driver when I'm not using the roads. I'm not employed using the roads. You're fraudulent by telling me I'm operating a motor vehicle when I'm not employed in any manner. You're fraudulent by telling me that I am required to give you any ID when there's been no crime committed. You're fraudulent when I mean, it can go on and on and on, right? So we really need to understand, again, that the supreme law of the land is nowhere near the statutory courts, nor the municipal courts. Okay? Not only that, Chevron deference has been repealed. You really, at all times that you've ever had in your life, probably, you have the most power that you've ever had. You just don't realize it. But it's that fear and intimidation that allows you to stay in where you're at. And I'm telling you right now, we got somebody coming up here soon that's going to speak about her recent win as well. So I hope this one was good for you. Y'all stay tuned for the next episode. Y'all don't forget the book down in the description, The Last Tread. It'd be a great holiday gift. And I really think you should get a personal, like a physical copy. I love books, as you can tell. I love books. Physical copies. I go hunting for them. But you can also get the audiobook too, and just digital copies if you want. Those are in the description. Please, I'm still asking everyone to click the petition, the traffic law petition, traffic law reform petition down in the description as well. And then, of course, if you didn't get the right to travel course down below with all the documents included, that's also in the description. I love you all. I am so grateful for each and every one of you. Your comments are helping every other person that comes through. Your comments are empowering. Y'all are amazing. I love you all. We're about to really push this through. And if you can't see it, just go to the comments. I love you. We'll see you on the next one.